And so there were three types of termination, okay? We have our neutral, the friendly, and the unfriendly. Okay, and so first we're going to talk about these neutral termination, which will arise in contracts that provide the parties with the ability to discontinue their relationship absent the fault of either party. So an example, this is straight out of our text. The owner might need to end the project because of loan financing or in a situation like this Target situation. For example, the seller cannot obtain a consent or release. If he can't, for no fault, of that particular party, then the agreement would need to terminate.
Target has been trying for years to put a store here on the corner of Western and Sunset, but a legal challenge put the whole thing on hold. And now, construction may finally start back up again, thanks to a new court ruling. In a town built on fame, this giant half-finished store has become Hollywood's most famous eyesore. It's been like this for several years, earning the nickname
the Target Husk.
Jess Hager lives nearby and knows all too well the Target saga that began back in 2014. That's when a neighborhood association sued the city for building a 74-foot tall Target on a site where heights were supposed to be capped at 35 feet. A judge agreed, forcing construction to a halt. 2 years later, the city council decided to alter height limits in the area to make the building permissible. But the neighborhood association sued again, successfully, after an LA County Superior Court ruled the city did not fully study the new zoning laws. So the project continued to sit unfinished at the corner of Sunset and Western. Fast forward to Thursday, and a California appeals court reversed the lower court's ruling, meaning Target may finally resume construction.
I'm pretty excited about the prospect of finally getting one closer to home.
The attorney for the neighborhood association issued a statement. Because today's decision reversing the trial court could have broad ramifications for land use approvals across the state, we believe this matter should be addressed by the California Supreme Court. Regardless, many folks are excited the Target Husk may soon be simply called Target.
That would be awesome, so I won't have to travel far to go to Target.
Right now, it's unclear exactly when construction here will resume, but a city council member says it will be soon. Reporting live in Hollywood, Peter Dowd, CBS 2 News.
All right. So I just want to say, imagine, I just look at everything from a legal standpoint, but I'm sorry. There were a whole lot of attorneys involved in that process for that to fall through like that. And all I can say is, when I see something like that, I'm glad I didn't have anything to do with that, because clients are relying on attorneys to foresee situations. This is just like, what? So you have to be able to have, as much as possible, to look into the future to see what kind of calamity could happen that you would need to, have some type of a termination agreement in termination provision in the agreement. Because can you imagine now, Target is spending a lot of money. You have builders, you have contractors, all kinds of agreements, and people that are expecting you to go through with this project, and all of a sudden it falls through. So you want to make sure that some type of eventuality is in place to be, so that you can stop to mitigate whatever amount of money would need to be spent while you're waiting for the courts to figure this situation out. And so I was telling you earlier, rather than to have the agreement to terminate upon receipt of the notice, the receipt of that notice should condition the actual event of termination on an obligation or a covenant that allows the parties to mitigate as much risk as possible when the termination obligation covenant is performed. Then the contract terminates on the happening of that particular event, the paying of all of the contractors or whoever that may be, if you are that contractor, obviously you would definitely want to make sure you get paid. The builder / contractor is not at fault. Okay, so that would be maybe an example of a neutral type of a termination that would need to occur. And this example is provided. If the owner terminates this agreement for a reason resulting from no fault of the contractor, the owner shall pay the contractor for all completed construction work on the project and for all proven loss or expense in connection with the project's construction. Okay, then on the date of the contractor's receipt of the payment in full of all termination costs, I put this in red here because I see a lot of terms, there's a lot of loose terms in some of your agreements that are not defined anywhere. See, once I start drafting these provisions, then I'll say, okay, maybe I might need to go somewhere and define termination costs. And this agreement terminates at that point. At that point, not necessarily on the receipt of the notice, because then the party has to make sure that they can get paid. After that occurs, then neither party has any other rights or remedies, and they walk away. And so once that termination obligation is performed, then the contract ends and the parties walk away without common law rights or remedies in the neutral termination context.